Well, I appreciate you all letting me share this time with you. My name is Stanley Charles Thorne. I'm an attorney from Texas, and I have a nationwide public interest law practice that assists organizations like the Alabama Family Rights Association. I am an attorney of 25 years plus, and my mission in life is to help use the U.S. Constitution as a shield to protect fit parents and their children from unwarranted government interference.
Is there a lot of abuse going on, Mr. Thorne?
Well, there's systemic pervasive abuse, but it is something that is based on a lot of misconceptions. And one of the reasons that I'm in Alabama is a case from the early 1900s, and the Alabama Supreme Court said that a child of divorce is deemed a ward of the state.
Wow.
That's an attitude that you see in courts nationwide, so it's not an uncommon attitude. But it's the only state in the nation of which I'm aware that has actually articulated that as a Supreme Court case.
Does that hurt us, do you think?
Well, it sets the stage for the court to elbow each parent out of the way and become the super parent that micromanages the lives of both fit parents. And Kenneth was right on the mark. When we focus on the rights of fit parents, we're not talking about those parents who do abuse, neglect, or place their child in imminent peril. Everybody with any sense wants the state to intervene and protect the innocent child from the wrongdoing parent. But there is an enormous system that treats fit parents as though they're unfit, and that's where this pervasive discrimination comes into play. When you take two parents, both of whom want to be a meaningful part of their child's life, and you systemically discriminate against one in favor of the other for no good reason, then that unwarranted discrimination is so unfair that it becomes normative, and that's what's happened in this country. Most courts have some sort of standard rule, and it's typical in all the states. In Tennessee, for example, where I worked on a case for 3 years, the local judges implemented a so-called 80-day rule, where immediately on the filing of a divorce action with no notice or hearing, one parent was only allowed to see their child 80 days a year. There's no reason for that. Children, the social studies data is conclusive and dominant that children get benefits from each parent, and each parent brings different things to the table in the child-rearing arena. And so children that only have one parent, whether it's the male or the female, suffer deficits that they don't have to suffer. This inflicts needless harm on children by the thousands nationwide, and Alabama is simply no exception. So this bill is designed to have the starting point for two fit parents to be treated with equal dignity, equal respect, and equal opportunity, and it's that simple.
In Kenneth's first appearance on our show a couple of months ago, he highlighted how a lot of what you're saying seems to adversely affect the father more than the mother, that the courts tend to lean more toward the mother than the father in divorce cases. That's not always the case, but it seems to be the prevalent case, and that sometimes the men seem to suffer a little bit more than the women in this arena. Is that your experience?
It is my experience, and I could furnish data that shows that nationwide about 85% of all divorce actions are initiated by the mom, and coincidentally, about 85% of all lopsided custody determinations favor the mom. So only in about 15 to 18% of the cases do the dads get primary custody. So the discrimination, the lopsided custody time splits almost always disfavor the father. Now that's not always the case, but what frequently happens is that the so-called best interest of the child that the court takes control of ought to be first and foremost for the parents to decide. And if you have two parents, and if the court systemically started with treating them as equals, then for the most part they would work out their differences, and you would have a child that would benefit from having two engaged parents being a meaningful part of their life. That simply doesn't happen in Alabama or most of the other states now as the starting point.
Kenneth, there seems to be a prevailing attitude among some that the father doesn't always necessarily want custody of the kids, that he willingly gives that over to the mother. And I assume that through your work with Alfred that you're proving that that's not usually the case.
Well, you're correct. That is not the case. And what I'm finding is by the time the people out there find Alpha, our organization, they have pretty much been armstrong, or their arms has been twisted to accept an agreement as far as the 80-day rule. And then by the time they reach us, we try to educate them on the process. It's really difficult for them to go back and change the custody ruling. But for the most part, from the research and from the people I talk to daily, is the fathers is really, you don't have a say so. You go into the courtroom. Alabama has adopted the 80-day rule also, and the impact of that is, as you said, even out of schools. I'm on the Birmingham Education Task Force, and then we're seeing major impacts in the school. Alabama has 43% dropout rate, and of that, 71% is from fatherless homes. We have 85% of youth that's sitting in our jails is from fatherless homes, and then 71% of teen pregnancies is from fatherless homes. So my question is the education part. If the courts is aware of this damage, why are they still forcing one parent out of the child's life?
Why do you think that is?
Well, there's unknown to most people is there's a huge amount of federal money that flows to the states under the guise of subsidies, and that federal subsidy money is paid only on the most lopsided time split. The more equal the time split between the two parents, the less subsidy money is paid. So you have this perverse federal incentive that actually allows the state to make money on the most lopsided split. And coincidentally, that comes at around the 80-day mark. So there is a federal government policy that gives the state a financial incentive to discriminate against parents. What really is, you mentioned Rosa Parks earlier in the show. I'm reminded that above the main entry to the U.S. Supreme Court building is the inscription up on the portico above the columns, "Equal justice under law." That is a noble and honorable and desirable policy, preeminent policy for our laws to be based upon. That's all Rosa Parks was looking for: equal justice under law, equal dignity, equal opportunity, equal respect. That's all these parents are looking for. They just want the equal opportunity to parent, and they don't want the state elbowing them out of the way for no good reason. This bill in Alabama is not unlike bills that are being presented to legislatures all over the country, and the time is long past for this sort of modification of the state policies. It's time for children in Alabama and elsewhere to have the benefit of both their parents and not have, there's the federal government has a fatherhood initiative. Under fatherhood.gov, you can find all of these statistics and these deficits that children suffer for lack of a father. The single greatest cause of fatherlessness in America is not fathers who do not care. There are those, and they're a small percentage. But the single greatest cause of fatherlessness in America is court-ordered fatherlessness. And this bill will help bring that to an end.
It's hard in divorce cases to weed out things like emotion and conflict between couples. Do those issues sometimes muddy the bigger picture and often lead to this problem we're discussing, Kenneth?
Yeah. Well, divorce, yes, you're going to have that. But you expect our leaders, the people that's put in the positions to protect our constitutional rights. The courts, they are sworn to uphold and protect everyone's rights, constitutional rights that enter the courtroom.
And it's their responsibility to, wade through all of that and get to the core issues.
Right, you have to. If you focus on individual personalities and emotions, yes, you will, as history has shown, you will rule for, what word I'm looking for here, as far as what's convenient.
Sure.
So basically, if you rule in favor of one parent because of the emotions, yes, it's called convenient, but our Constitution is not based on convenience; it's based on protecting your rights. Our next meeting is December the 16th, at the Double Oak Community Church here in Birmingham. And I do ask all the listeners, please come out. Just get we need your help, your support. We need the voices of the general public to come out. And our website is www.alfra.org. And my number is 626-9458. Please call me if you have any questions. But I want to emphasize that we're not trying to discredit any mothers, fathers, or grandparents. We're saying, listen, it's time to stand up for your rights. Let's do what's best for our children. Let's do what's best for Alabama.
The next meeting of the Alabama Family Rights Association, again, is coming up on December the 16th, right?
Oh, yes.
You can go to the website for more information, or you can call Kenneth. And Kenneth, again, your number is?
626-9458.
They need your support right now, especially with the bill coming up after the first of the year. And Mr. Thorne, you think this bill will go a long way in changing attitudes here?
It's a great start, and all it is a starting point bill. It starts out with parents on an equal footing, and it's long past due. And the children and parents and grandparents of Alabama will be the great beneficiaries of it if this bill passes.
Kenneth Paschal is with the Alabama Family Rights Association. Kenneth, nice to see you again. Thanks for being on the show again.
Thank you.
And Stanley Charles Thorne is Chief Counsel for the American Family Justice Project. Mr. Thorne, nice to meet you. Thanks for being on the show today.
Thank you so much for your time.